Good afternoon, everyone. We're just waiting for some folks to join, including one of our panelists, so we're going to get started right away. And if I don't see where people are being muted automatically, but if you could just mute yourselves for now, that will help to preserve sound quality. And it seems like we're at about 26 folks, right, Bernadette?
I'm seeing 32.
You're seeing 32. Okay, well, I think that is a good number to get started at. All right, well, I'm just going to kick it off then, and hopefully this will all fall into place. Good afternoon, everyone. I'm Gail Winchin. I'm the president of the Connecticut Valley LERA, Labor and Employment Relations Association. We are delighted to have you here today for our first virtual program of the season. We've been having some technical issues, so please bear with us as we manage our panel discussion this morning. I want to just give a couple of housekeeping notes before we get started and also talk about our upcoming programs. So we do have a program coming up in November, Hot Topics in Labor and Employment Law. So changes in Connecticut state law that impact employment and labor relations will be on the docket for that presentation. On December 10th, Andrea Barton-Reeves and her colleagues from the Connecticut Paid Leave Authority will be joining us again because the new paid leave law goes into effect on January 1, and many of us on this call need to be prepared for that. So that will be on December 10th, and all of this information will get posted to our website very soon. And hopefully all of you have paid your membership dues, and if you have not, please go to our website and do so on the portal. If you have any issues or problems, just send me an email and I will help to troubleshoot. But we do like to make sure that we collect dues from our members so that we can support the work that we do as a chapter and the work that National does in supporting us, which is fantastic. And so thank you to Bernadette and Emily from National LERA for hosting these webinars for us. So at this point in time, we're going to kick off our program. We are recording the program, and you will get a link to the recording probably within the next day or two, and we will issue CLE certificates for everyone who needs one. And we do have a great presentation today. Our moderator is Lee Williamson, who is an arbitrator and I believe mediator as well, but has extensive experience in labor relations. And he's going to be moderating our panel, which includes Dan Livingston, who is a lawyer representing primarily unions and is known from time to time for representing the state employee bargaining unit. So you may have seen his name in the news. We have Kyle Moore, who is the Deputy Assistant General Counsel for the National Labor Relations Board, as well as Jose Santana, who should be joining us from the State Board of Labor Relations. I think he's having some problems with his camera at the moment.
I don't see me.
Oh, hi, Jose.
Oh, you see me now?
No, not yet, but hopefully you'll chime in. And I will be moderating the chat and also chiming in on occasion as a management side lawyer.
My camera's not working.
Your camera's not working. And I know that the panelists would like this to be interactive. So I believe Lee is going to kick it off with some questions and looking for some responses from the panelists. And then if you have questions, you could either, raise your hand, put a note in the chat, we'll call on you, and we'll kind of let it go from there. But we do want this to be an interactive conversation on this very important issue. So at this point, Lee, I'm going to turn it over to you.
Okay, thanks, Gail.
Good morning or afternoon, everyone. Let's start with just a general understanding of where we are. 680,000 people in the US have died from COVID-related experiences. That frames where we're going to be. So let me back up and say we have collective bargaining issues dealing with the immediacy of this pandemic, and the pandemic also is going to set the stage for possible
They hear me, but that's it.
post-pandemic changes in the collective bargaining process. So I just want to start that with that general observation and then go into a little more specifics for 1 second. In Connecticut, Governor Lamont has issued an order under his emergency authority that all state employees, K through 12 teachers, staff, early childhood staff are mandated to be vaccinated by 9/27. Interestingly, at least that I'm aware of, his emergency powers expire on September 30th. The mandate is again by September 27th, or the employees will have to follow a testing option. There are exemptions for those who are medically exempted or have sincerely held religious beliefs. Hold that for a minute and jump to Massachusetts. Massachusetts State Police Union has just sued Governor Baker for his order that requires state workers to all be vaccinated. The State Police Union has indicated that they are suing because they think there should be an option available to them for weekly tests and wearing masks. They're suing because Governor Baker's order indicates apparently that you must be fully vaccinated or face disciplinary action up to and including termination. And further, the state police's lawsuit is seeking a presumptive protection order, saying in essence, if an officer becomes ill or is forced to retire or dies from COVID, or experiences side effects from the vaccine, that will be considered in line of duty injury, and all the benefits that flow from that will be available. With that general backdrop, let me ask the panelists, how does government orders interfere with collective bargaining obligations in general? Dan, start us out.
So there's a lot in that question and that background. So, let's start with the fact that the vaccination requirement is a mandatory subject to bargaining. There's no doubt about that. And that normally if an employer seeks to just issue a policy saying you must be vaccinated, absent some waiver by a union, that has to be bargained with the union, and exactly how it's bargained will depend on whether it's private sector or public sector. So the difference here is in the premise of your question is that the requirement comes via an executive order, and not just under the normal executive authority that a governor might have, but under emergency executive public safety and health executive order, which gives the governor actually the authority to change statutes. So the question of whether or not the actual decision to impose the mandate is subject to collective bargaining is, I think, undecided by any court, effectively because of the governor's ability to actually change law, and how would that how that implicates the duty to bargain, I think it is undecided by any court. But I want to just take maybe a second to take a step back, because normally the duty to bargain cases are in a context where the union is challenging something which from its point of view is only bad, and presumably from the employer's point of view is good. So subcontracting or something like that. A mandatory vaccination order from a union's point of view, or at least the unions that I work with, is in fact a double-edged sword. There are a lot of our members who support the idea of mandatory vaccination because it affects their safety. And the unions that I work with actually have been very vocal in trying to insist on things like testing and vaccines being provided by the employer. So this is a more complicated situation for unions than most when you talk about the duty to bargain. But the general conclusion, at least the unions I work with, is that the best thing that unions can do in this context is to bargain the impact of the executive orders rather than try to bargain the decision. I do want to just correct one thing. The governor's executive order is an actual mandate. Vermont's executive order is an actual mandate on some state workers. If you work in a state hospital or a long-term care facility, you do not have the testing out option unless you have either a religious or a medical exemption. So I'll stop there and let other folks talk.
Well, let's pursue that duty to bargain. Kyle, from the National Labor Relations Board's perspective, have they issued any either advice memos or decisions on the duty to bargain in emergency situations?
Thanks, Lee. Good afternoon, everyone. I just very briefly, so I'm currently a DAGC in our injunction litigation branch, but at the start of the pandemic, I was a staff attorney in the Division of Advice, and I worked on several of the first COVID issues that we received in advice. And I'm sure a lot of folks are aware of these already, but just in case you aren't, I'd like to direct your attention to two General Counsel memoranda that issued under prior General Counsel Rob. That would be 20-04, which is case summaries of the duty to bargain during emergency situations that we released in, I believe it was April or May of last year. And then 2014, which is a summary of advice merit determinations. Of course, since a lot of, the cases in which we authorized the region to pursue litigation are still ongoing, I don't think we've released many actual advice memoranda at this point, but that's a good place to go for just a summary of the general issues. I should also say that nothing I say should be construed as indicating how the board might rule in any particular case, or how our new general counsel, Jennifer Abruzzo, is likely to view any particular issue. But I think there are two cases in that first memo that I mentioned, the cases pertaining to the duty to bargain during emergency situations that are worth noting, and they both involve orders from local government officials during public crises. The first is Port Printing and Specialties from 2007. That's 351 NLRB 1269. And there, the mayor of Lake Charles, Louisiana, ordered a mandatory evacuation in anticipation of the impending arrival of Hurricane Rita. The employer closed its operations, laid off all its employees without affording its employees union a notice or an opportunity to bargain. In the weeks after the hurricane, however, the employer worked to repair the damage done to its facility, and it used some unit employees, but also some non-unit employees and a supervisor. Approximately a month after the hurricane, the employer sent unit employees a letter permanently confirming their layoffs, and at no time did it attempt to bargain over any of these decisions. So citing the board's economic exigency doctrine outlined in Bottom Line Enterprises that I'm sure a lot of folks are familiar with, the board explained that, in certain extraordinary circumstances, an employer can be excused from the duty to bargain, but that freedom from bargaining only applies during the emergency situation. So in this case, the board found that the employer did violate Section 885 by failing to bargain over the effects of the layoff after the hurricane and by failing to bargain over the use of the non-unit employees to perform unit work after the hurricane. In a second case, Gannett Rochester Newspapers from 1995, and that's 319 NLRB 215, local officials banned non-essential travel during a severe ice storm, and the employer had two units of representative employees. One unit had an extant collective bargaining agreement with a zipper clause. The other represented unit was in the midst of negotiating a new collective bargaining agreement. And there, neither the existing collective bargaining agreement nor the expired one addressed, leave issues during public emergencies. But because the existing or the unit represented under an existing collective bargaining agreement had a zipper clause, the board found that the employer was, privileged to act unilaterally with how it treated the leave issues during the ice storm, but that it violated 885 by refusing to bargain over issues stemming from the ice storm in the unrepresented unit. So I think really to echo what Dan just said, in certain circumstances, initial decisional bargaining due to a crisis might be excused, but the board has traditionally, required effects bargaining still during emergency situations. And I think it's always important to look at, if you have a contract in place, what does that contract say? So I'll leave it there and see what anyone else has to say.
Gail, anything from the management side?
No, I mean, we're kind of in the trenches here. We deal with the healthcare workers union. They represent about 1,000 of our employees. So we were at the very beginning of August, contemplating, we were just on the cusp of deciding whether or not we were going to issue a vaccine mandate when the executive order came down for the long-term care facilities that we operate. And so, we were in the process of gathering data about how many employees we had who were vaccinated. What was this going to look like in terms of the process for managing exemptions, bargaining with the union. And candidly, to Dan's point earlier, that there are, times that you're actually in alignment. And for us, we were very lucky that this was one of those cases dealing with the healthcare workers union that they were saying very publicly they wanted the vaccine mandate because they were working with their co-workers, many of whom, were coming into locations sick. And that's how it was spreading in congregate care settings. And a lot of them had significant impacts as a result of this pandemic well before the vaccines arrived. And they do very difficult work. And they want to be protected, and we want to protect them, and we want them, we have the general obligation under OSHA to provide a safe workplace. And we said we're going to use all the tools in our tool belt to do that. And vaccines is one of them. So what we're doing right now with the union is what, Dan and Kyle have talked about in terms of the effects. Okay, we're all in agreement now that this is something that we need to do across the board because of the way we operate. And, what are some of the effects? And of course, the most challenging is for the programs where the executive order is in place, you have very few options as an employer. Your employees either have to be vaccinated, they have to have an exemption, or they're not qualified to work anymore. And then for our workforce and the work that we're doing, much like people are seeing across the communities, there are not workers out there to backfill these jobs. So it presents multiple challenges.
Well, how far can, in the scenario of collective bargaining, how far can an employer
I'll just say, I think that's a great question, Lee. We've been relying upon the guidance from the EOC that has said, simply asking for proof of vaccination is not an impermissible medical inquiry. And so that's all we want. We have said, just let us know, are you vaccinated? So we know how, because we have to report on the status to the state. And then likewise with the exemptions, but it becomes very dicey, and candidly, it also requires a lot of human resources to manage this process like that.
Let me
Dan,
press this question, and then we'll get to Dan too.
Yeah.
Accommodations have to be made for medical exemptions. Does the employer have to know, and does the employee have to verify that they have certain medical exemptions which would otherwise not be known to the employer?
Dan, you want to take that first?
Yeah, so first of all, Lee, you mentioned a little bit earlier about, talking about the booster and the, could an employer create a mandate that says you have to get the booster if you're over 65 or if you have one of the immunocompromised. And to me, the answer to that is clearly no. The premise for the employer's right to insist on the vaccine that at least that the unions have supported is the risk to coworkers and the public. The idea of providing a booster to people over 65 or who are immunocompromised is about their own risk. So certainly the balance between the collective good and the individual good is a very different thing if what you're saying is I require you to get a booster because it will keep you healthier. And I think the union, at least from our point of view, the unions would look at that very differently than one that's about protecting coworkers and the public. But I do think that the EOC does allow employers to request verification of if you're looking for a medical exemption. I do think they allow employers to request that, and it's required to be kept as confidentially as other sorts of medical information. So you wouldn't have to provide it to your direct supervisor or inline supervisor, but somebody in HR in a confidential manner could, if you claim to have a medical exemption from a vaccine that requires some sort of accommodation, I do believe you could request that information. And certainly the employers that I know of that are doing vaccine mandates are requesting some sort of medical verification if you're going to be exempt. Religious verification is a lot more complicated, I think.
And I was going to get to that point now. What if an individual says, I have a sincerely held religious belief, and there is some doubt on the part of the employer that that's true? Where do we go from that? Can grievances be filed? And Kyle, feel free to jump in on this if the board has dealt with that issue. So anyone? Gail,
I'll let Dan and Gail tackle this one. I am not an expert on the religious exemption issues.
Yeah, I also want to go back to the medical exemption, because what's really interesting again, we're operating under two executive orders, one under the Department of Public Health, one under the Department of Education. But the Department of Public Health, the medical exemption language is actually very narrow. So you can't just have an exemption from a doctor that says, for medical reasons, this person can't be vaccinated. I think it's limited to things like you have an underlying, like you're allergic to an ingredient in the medication, in the vaccine, or you have a specific diagnosis, or let's say you need a deferment because you're pregnant or you've had COVID, and so it's not recommended that you get the vaccine for at least 90 days. So I think it's really important for people to understand that employees can't just be showing up with a general kind of, note from any old medical provider. The executive order is very specific about who that note has to be from and what it needs to say. With respect to the religious exemption, I think that that's probably the harder issue for us to tackle. Most of the, primary religious groups do not have any objection to either vaccinations or the ingredients in the COVID-19 vaccine. So that's challenging. And we have told people on our form that if you're going to request a religious exemption, it can't just be a political statement. It can't just be because I feel like this is not good for me or whatever the case may be. But crossing that Rubicon in terms of challenging whether it's a sincerely held belief is a difficult task. And I'll let Dan speak to the bargaining issues, because that actually did come up with us when we've been talking to the healthcare workers union. So I'm interested in your perspective.
So I think that one of the more complicated issues to try to figure out is what role the union should play in the exemption process. So the exemption process is largely governed by state and federal law. Religious exemption and medical exemption have state and federal support, and individuals who are denied them have places to go to challenge the denial. On the other hand, they also have rights as union members under the collective bargaining agreement to file grievances. Perhaps if an employer discharges someone because they claim a religious or a medical exemption, and then that person files a grievance, then the union has an obligation to, at least in my view, has an obligation to investigate that grievance and to prosecute it to the extent it sees a violation of the contract. So, the employers that I'm most directly working with have decided that they're not going to discharge people for failing to follow the mandate. They're going to separate them from work. Perhaps administratively, perhaps some other form of non-disciplinary separation. So that also raises other questions about what the provisions of the collective bargaining agreement might be that apply in those circumstances. But I do think the unions have an obligation in the event someone files an exemption and it's denied, and then the employer takes an adverse action of some sort, and the individual files a grievance. You have to consider that grievance like you would consider any other grievance. And if you feel the collective bargaining agreement has been violated by the denial, you have to then you have to represent the individual. At least on the state side, we had it come up once around a testing mandate where an individual claimed a religious exemption from the testing mandate in corrections facilities, and then the employer placed the person on paid leave to begin with, and then investigated the claim. The individual said the religious exemption is I'm a Christian, and provided no other information, and the employer determined that was not a bona fide religious exemption and stopped paying the person. And the union determined that the grievance didn't have merit because but that was based on the facts, based on an investigation of the facts, and that the religious exemption didn't apply. So, I think it's a fascinating question how the union can carry out its duty, represent its members most effectively in that context.
Jose, we haven't heard from you because you're not on the screen, but do you have any input on this? You have to unmute yourself.
I think Jose may be having some technical issues.
Yeah, we will try to get Jose's input as we go along. Interestingly enough, Zach, I'll get to your question in a minute. Interestingly enough, in 1979, the State Board of Labor Relations issued a decision that in its conclusions of law, I'll read just briefly, where a Board of Education is faced with an emergency situation in the operation of schools, it may make unilaterally temporary assignments of bargaining unit members that are reasonably necessary to meet the emergency, even though such assignments are not expressly permitted by contract or precisely within the dimensions of the job description. That happened at the Hartford Board of Education. The decision number is 1777, issued July 2nd, 1979, with Fleming James as the chair. That happened when custodians went on an illegal strike, and some of the principals had to pick up some of the stuff in the school, and there was a charge filed. That's going back to where Kyle mentioned, if the MV transportation case dealt with generally a hurricane, and the State Board of Labor Relations dealt with an illegal strike that was very temporary in terms of an emergency situation, where does temporary start and stop with regard to the duty to bargain?
Yeah, so MV transportation concerns the contract coverage issue in collective bargaining agreements versus the clear and unmistakable waiver. But the port printing and specialties case involving the hurricane in Louisiana, I mean, I again, without wanting to really weigh in on, what would constitute an acceptable period of time and what wouldn't, it certainly seems from the board's previous case law that the period of the emergency is pretty brief, right? I mean, if there are things you need to do to respond immediately to the emergency, you can probably do those, and that would fall under that exigency exception. But anything after that is likely to be, something that would be bargainable. I think there was another case in that memo I mentioned, 2014, which is just a summary of an advice merit decision in which an art center of some sort, due to the COVID-19 pandemic, they had lost a lot of money, and therefore, they decided to lay off a substantial portion of the staff. They argued that was excused. And former General Counsel Rob and advice said, that is caused by the COVID-19 pandemic, but it's not such an emergency and so an immediate of a need that it would excuse, bargaining with the union over these layoff decisions. So I think it's probably a shorter duration rather than a longer duration, if that makes sense.
Can everybody hear me?
Yes, Jose, please.
Again, we're still trying. Back to the Hartford Board of Ed case in '79. Yes, it was very limited in regards to the circumstances there. The strike, I think, lasted maybe a week at most, and everything went back to normal. That case has, in talking to Lee about it, it's still good law. We have, I did some quick research, and the last time we actually had a case on an emergency situation was a Town of Orange case number 2969, 1991, which dealt with a overcrowded parade situation in that small town of Orange, in which we said that in that particular situation that we found that to be an emergency situation, but only in regards to it being a temporary for that particular time frame. We have cases cited on other emergency issues that were not resolved or were not, put it this way, was not determined by the board. They determine the issues on a separate unilateral change issue, for example. But as far as recent as 2019, that case has been cited. But it appears that in all of them that they've been for very short time frames. And obviously in this situation, we're going way beyond, that short time frame.
Thank you. I'm not sure. I believe everybody can view the messages in chat. And so Zach has asked a question. You can access it, but I'll just read it. How does the fact that our public sector bargaining laws, TNA mirror, prescribe binding interest arbitration for midterm issues affect the analysis? If it can take more than 100 days to complete the midterm bargaining arbitration process, then how do you negotiate, resolve impact issues before an executive order takes effect? I think under the TNA, there has to be an agreement to do midterm bargaining. I'm not sure a mirror, but Dan?
So under the normal
Yeah.
situation, an employer seeks to make a material change in, any condition of employment that isn't already dealt with in the contract would have to bargain with the union prior to the change, and would have to, if there's not an agreement, would have to go through the interest arbitration process. And so this gets to the question of emergency that I think Kyle was talking about and Jose was talking about. I don't know, the state board has certainly used that phrase to allow employers to make temporary unilateral changes pending carrying out their bargaining obligation. And as Jose said, at least all the cases I'm aware of, it's temporary has been a very short period of time. So I think we'd have to acknowledge that the state board has never dealt with a situation like this before, for a number of different reasons. And so
That's acknowledged.
and so if there's an executive order and a demand to bargain, and the employer says, well, I'm going to implement now, I'm not going to wait until the completion of an arbitration, and the union then goes to the board and files charges, the board is going to be facing an application of the emergency doctrine that it's never had to consider before. So, and I won't say I could predict how that will come out, because at least in all the circumstances I'm involved, the unions are finding other ways to deal with it. And we've not on the state employee side, we just signed an agreement with the Lamont administration about some of the impacts of his order, and we're going to either settle or arbitrate some of the other impacts, but we have not asked that the order be stayed pending that bargaining, because we're in the middle of this 100-year pandemic. And also, as I said, this is one of those situations where we have a very strong interest in workplace safety. It's not like subcontracting where we just want it to stop. Workplace, we're as interested in workplace safety or more than the employer. So we want to try to find the right balance rather than end up in a lot of litigation if we can avoid it.
Gail?
Yeah, I mean, I think, as I sit here, I'm thinking about, well, what does it really mean at this particular point in time, a year and a half into a pandemic, for there to be an emergency? Now, I know that that's the mechanism by which the governor had to thread his needle in order to get his emergency orders or executive orders in place. And I think for us, it was just, again, wanting and needing to provide a safe work environment, just seeing the numbers, where the Delta variant was raging, and, less than half of our workforce was vaccinated. And so, it was really a matter for us to try to say, how do we get ahead of this? And fortunately, like I said, at least on the theory of the vaccine, we, our union representatives were all in agreement with that. But we said, let's get to the table as soon as possible, and invited the union to help us negotiate our policy around this. because we also felt that that was the right thing to do in order to get buy-in from the very people who are being impacted by this. But, you know, time is not on our side. You know, we met with the union yesterday and we said, as of today, you know, we still have a good number of employees who are not compliant. And it puts us in a very difficult situation.
Well, let's assume that you have those employees that, for whatever reason, are not complying. In your next negotiation, will you address that in your collective bargaining contract to push for the use of non-unit personnel in emergency situations?
Well, we
Generally.
already have language to some extent. It's really more about how we schedule people. But, you know, this is, and I'm sure Dan can relate to this as well, you know, this is coming at a time where there is a significant staffing shortage throughout the state. And so, you know, on the one hand, you know, we said very clearly, we do not want this to result in laying people off. We don't see this as a punitive measure. This is a health and safety issue. But in some ways, our hands are tied. Under the executive orders governing long-term care facilities, the state can fine us $20,000 a day if they come in and audit and find people for whom they're not vaccinated or there's no exemption on file. So our options are limited. And we hope we don't have to take any other actions. Dan, what do you have to say about that?
Well, I will say that, you know, again, for most of the state employees, there's a test out option. And so obviously that takes a lot, that balance works in ways that isn't likely to create staffing shortages. But for the state employees in long-term care facilities and state hospitals, the coalition did call on the Lamont administration to amend the executive order to allow, in the event of a staffing crisis, to allow temporary use of a test out option so that the parties can cooperatively try to figure out how to handle the crisis. And part of the premise of that is that if this is really all about public health and safety, and we're considering adopting or adopting a policy which creates huge staffing shortages, you actually can, you know, some of these residents in long-term care facilities are more likely to die because you have to transfer them to a hospital or something than they are from catching COVID. So you have to, there ought to be a process by which if the unfortunate happens and there's a genuine staffing shortage as a result of this, that we have a temporary test out option and the parties then work cooperatively to address the staffing shortage. We haven't heard a response yet from the administration, so I don't know what they're going to, you know, you only have until Monday, theoretically. Although I will say that on the state employee side, the chief operating officer for the state put out an email last night indicating that employees should go to work on Monday regardless of whether they had complied. Because of some of the complications of implementing the policy. So I'm not sure what's going to happen next with that. But we definitely have to take the staffing shortage issues into account. If the underlying premise is public safety, adopting a policy and being so rigid about it that we endanger public safety doesn't make a lot of sense.
So in the new wave of working at home, what has to be negotiated, if anything? For example, if employers say to the employees, you must work at home for whatever period, is the employer obligated, or has the union sought to have the employee compensated for internet, for the chair, to buy a new chair so they could work at home? If the employer doesn't have the employee use a laptop, to have the employer provide the laptop. And if the employee uses their own computer at home, what access does the employer have to that computer? Have those been discussed at all in collective bargaining? And should they be?
Yeah, yes, and yes, if you're asking me.
Mhm.
We've had lots of very vigorous interaction with first the Malloy administration just to get the process started, and then the Lamont administration about telework and about the employers. If the employer has an equipment requirement, the employer's obligation to provide that equipment, and about if the employee uses their own equipment, what aspect of the equipment the employer has access to. Most of those things are things that cooperative parties can work out. Most of those things we figured out. Some things we may end up having to arbitrate through interest arbitration, but to me, it's clearly a mandatory subject to bargaining. It's clearly a working conditions issue, and so it clearly has to be bargained. And telework is something that is, strongly in the public interest, strongly in workers' interests, and so the parties working cooperatively in ways to encourage that. Even without the pandemic, that was a good thing, and obviously with the pandemic, it's become essential.
Kyle, is it a mandatory subject of bargaining?
Well, I'm unaware of any case in which the board has talked about telework in terms of mandatory subject of bargaining, but certainly, as Dan says, on the surface of it, it seems obviously relates to terms and conditions of employment. I would tend to think that it would be. And just an anecdote, our headquarters, staff has been teleworking for quite some time now, since the beginning of the pandemic. And I know our staff union had tried to get reimbursement for some of the things you talked about with relatively limited success thus far. But I like to phone a friend as well. I know Mike Cass is on the call, and I'm curious if he has any thoughts on the issue of telework and mandatory subject of bargaining.
Well, since we're asking for questions, Mike, you want to have a few seconds here?
Yeah, just a few seconds. First of all, thanks, folks. This is a very entertaining and helpful presentation. But for us, at least locally, there really has not been an issue with this. We all took our computers home. The agency was very understanding, and in fact told us if we needed to take a desk chair back home, we could do that. And aside from that, the major issue we've had is having somebody check the mail. But I'm very fortunate in that I have an office manager who has chosen to work in the office the entire time, even though she's most of the time by herself. So we really have not had any issues with it at all. And that perhaps it's just because it hasn't arisen, at least yet. Our agency is now gearing up for I keep thinking about a space capsule coming down to Earth, but for quote unquote re-entry into the office. And I'm anticipating there will be some issues with that. I know that the staff union for field employees is seeking to expand the number of days that employees can telework, and a variety of other issues connected with that. But it's all just up in the air and in process at the moment.
In terms of teleworking conditions being a mandatory subject of bargaining, do you think that would be under the NLRA?
My guess is it would be. That's completely a guess. And just so everyone knows, I was able to recruit Kyle to be on this panel, and we talked about it. And one of the things that we knew we would both be at a loss of is that we have a new general counsel, and she hasn't really weighed in on any issues related to COVID or reopening workplaces or anything like that yet. I can say that we are getting cases involving quote unquote unilaterally implemented impositions of requirements for vaccines, of testing, that sort of thing. One of the cases we have under investigation at the moment involves a federal contractor, which is subject to President Biden's executive order mandating vaccination. So But that's, again, just under investigation. No decisions have been made. And, you know, it might just, well, I guess Kyle's no longer in advice, but it might just end up in advice. And I'm suspecting, I know that there are some cases that are bubbling up from around the country involving this type of issue.
And I think from the arbitration point, there are cases percolating up through the arbitration process that will eventually lead to decisions. I know I had one in Michigan that's still active, but it's dealing with pay on a federal agency for COVID-related work. I think it's going to be settled, but we are seeing these cases starting to hit arbitration. So Zach, if you could respond yes or no, did you get an answer to your question? And let me pose a different question as we're waiting. This is a different area, but in September 6th of this year, the New York Times reported that, I believe it was for new employees, Delta Airlines said that unvaccinated employees would be required to pay $200 a month surcharge to stay on the company health plan. Few questions come to mind. One is, can a company put conditions of employment on new hires that may be contrary to the collective bargaining agreement? But more importantly, looking in your crystal ball, do you think that surcharges are going to appear in your healthcare policies? Or are we going back and trying to do the incentives with the wellness program? So what's your crystal ball say?
I don't have a crystal ball, and I'm really eager to see how that decision stands up. I will say that we are already seeing some differentiation within the workforce. So for example, the executive order for the schools, for the school employees, much like with the state employees, says if you're hired prior to September 27th, you could have a testing option. But if you're hired after September 27th, you don't have that testing option. So you must be vaccinated or have an exemption on file. So, you know, I really struggle with that if we're kind of moving forward with this vaccine mandate out of a sense of shared, you know, community and workplace safety, then everyone, I feel like, should be working under the same work rules. And when you start having different work rules for different groups of people from a management perspective, that gets very challenging. I don't know. I don't know whether that surcharge on the insurance will hold up. I know the EEOC has said that you really, you know, from a wellness perspective, you can't have punitive measures implemented as part of your wellness program, like charging people more if they're cigarette smokers or have certain, you know, debilitating medical conditions. And in fact, as incentives, you can only offer something that is, you know, just you know, a small dollar amount if you're going to do a gift card or something like that, because otherwise it's considered to be arm twisting. And then, you know, it's no longer a voluntary program. So I guess for those people, maybe they say, I'm going to just, you know, go on my spouse's health insurance, or I'll go on the exchange, or they look for other insurance. I don't know.
So in a comprehensive wellness type program like the state's health enhancement program, it's not impossible to imagine that you'll see incentives. You know, again, I just want to sort of distinguish between the idea of things we're doing that with respect to employees that we think are in their interest, and things that we're doing because we're trying to protect coworkers or the public. And so, you know, to the extent that we think getting a vaccine is in an individual's interest, or it'll overall save, you know, health insurance claims, in general, the incentives and incentives to do the right thing work better than punitive measures. And I think you're going to see that in those kind of things more and more, to the extent there's science that support them. But I think that's a really different question than what we've been talking about most of this morning or afternoon. Which is where we're attempting to control individual behavior because we think it has an impact on coworkers and the public. And that's where I think, there's more employer justification for mandates and requirements and things like that, because we're not just being, big brother or big sister. We're actually trying to do something that goes beyond that.
But Dan, can I ask you a question? Does your analysis change depending upon the nature of the work? I mean, because, the state employees union, I know, represents very different segments of the workforce. You have the, people in public safety, you have people who work in office buildings. So what do you say to that?
I mean, our analysis changed in the sense that we didn't, we encouraged the testing out option as the right thing to do in general. In our communications with the administration, but we didn't challenge the fact that there isn't a testing out option in state long-term care and hospice. The unions have, as I said, sought to bargain over the impact of that, but we didn't challenge. So yes, we do recognize that the nature of the workplace changes the balance between the sort of collective good and individual liberty, or whatever we're calling the decision not to get a vaccine.
So we do have a couple of questions in the chat. Do you see those, Lee?
Yeah, I just saw it. And Joe Dubin, thank you. It was one of the questions that I think was asked early on, and I think it's an important one. Joe asked, as another layer of confusion, does it matter whether a vaccine only has emergency authorization as it relates to mandate vaccinations? Does the emergency authorization differ from full authorization in terms of what you can require of an employee?
I'm waiting to see if anybody else jumps in. We took a position on that we did, in terms of the balance between individual rights and collective rights, that the fact that a vaccine is only emergency authorized goes into that balance. And the governor didn't actually finalize his executive order until the emergency authorization had been replaced by final authorization. So I don't think it's an on-off switch. It doesn't really affect whether it's bargainable. But I do think in terms of the right balance, that's something to take into account. You're forcing someone to put something into their bodies that hasn't been fully and finally proven to be safe. So it would be wrong not to take that into account.
Yes. And we've had some similar issues or questions or concerns raised by some of our employees saying, well, it's not, these vaccines haven't been proven, they're not FDA authorized. And while it's a subtle difference, it's an important one, and that is, we're saying it's mandatory for you to be vaccinated as a condition of employment. If for whatever reason you don't feel comfortable being vaccinated and you're not eligible for an exemption, then unfortunately this may not be the work for you to be doing at this moment in time. So we're not taking the position that this is some new drug right off the shelf that no one's tested or whatever the case may be, and yes, you're forced to put it in your arm. You can make that decision, but it has consequences from an employment standpoint.
So for you, it doesn't matter whether there's an emergency authorization or fully approved.
Correct, because, and it's interesting because the executive orders specifically say that to be vaccinated and to be therefore compliant with the executive orders, it could be any one of the 3 major vaccines that are being used in the United States right now.
Yeah, but that doesn't answer the question of the emergency approval versus the full approval. I think early on, prior to the full approval of the vaccines, people who raised the legitimate question.
Right, but only one has been fully approved, and that's the Pfizer vaccine. And I believe it's actually, they're calling it something else on the FDA once the FDA version comes to market. So I don't even know if that FDA-approved version has actually been administered yet.
So I would just add that several federal courts have addressed this emergency use question, and they've all found it to be not relevant for purposes of their analysis, which of course is different than mandatory subject to bargaining and all that. But I'll just add that.
Thanks, Zach.
I mean, I do think it's relevant, you know, but I think that it comes down to how you see this balance between individual rights and collective rights, and that's going to vary union by union and workplace by workplace. There's no doubt that from the Lamont administration's point of view, the fact that there was about to be FDA full approval was a major factor in the governor's decision about when to issue the executive order. But yeah, it's just, to me, it's just a factor in the balance. You know, I see the question about the qualification issue. So should I jump to that, Lee?
Please, why don't you read the
So-
question just so everybody has a good understanding?
So is the failure to get vaccine or tested, is it a qualification issue or a discipline issue? And, you know, that has turned out to be very important to most of the unions I'm working with to treat it as a non-disciplinary issue. And it has to do, I think, with respecting the member, even if we don't respect the member's particular opinion. So, you know, there are some people not getting vaccinated for some reasons that some of us might think are fantastical, or maybe stronger words than that. You know, we have an incredibly divided country, including about science, but so we may not respect the opinion about why getting a vaccine is allegedly a bad idea, but we respect the person. And so if a person acts on a sincerely held opinion and chooses not to get vaccinated, that's not misconduct in my view, and in the view, I think, of a lot of people I represent. And so, you know, you discipline people for misconduct. So there's consequences, and if, you know, on the state side, it's likely it's unpaid leave for some period of time, and then they're talking about some other form of non-disciplinary separation, layoff, whatever. But it is important. That distinction is important to most of the people I represent for the reason I said, because it's not misconduct. It's maybe misguided. In my view, it's totally misguided not to be vaccinated, for my personal view, but I respect the people whose opinion I don't respect, if that makes any sense. I respect their right to have an opinion and to act on it.
And Jose, if you have any opinion, just jump in, because I can't see you.
Yeah. And on this question, not really, to be honest.
Okay. Okay. Do you think the whole issue we're talking about is going to see an
Collective bargaining.
increase of work study committees within the labor management relationship? Or work safety committee, rather, not study. Are those going to be revived or established, or is that not something that is on the horizon?
I mean, I think that yes, I do think that workplace safety has gotten increased attention. And so, I mean, there always have been, not always, but there's long been workplace safety committees. But I do think the pandemic has engendered some more energy into those committees, and into the idea that there could really be a mutual interest in paying more attention to workplace safety than sometimes has happened in some workplaces.
Yeah, and I think, Lee, it probably depends upon the type of the workplace. You know, if you're in a healthcare setting, if you're in a providing long-term care or serving people who have underlying illnesses where, you know, the infectious disease, and you know, is an issue that could, you know, may well be present in the workplace, as opposed to somewhere where, you know, people are working in an office building and they may be getting, you know, an airborne pathogen from, it's not work related. So I think it really depends upon what's the nexus to the work, and that will drive the answer to your question.
Will there be negotiations about hazardous pay now? in a way that we haven't seen before. Police and fire usually have some differentiation. Hazardous pay, are we now going to expand that?
Yes. I mean, I think, but look, the pandemic, this is not my quote, but someone said one of the things that the pandemic has revealed is we tend to pay the least to those upon whom we depend the most. You know, I think about grocery store workers or UPS drivers or whatever, and I think there is a lot more attention and focus on the fact that in a pandemic, those people are putting their lives on the line in ways that the rest of us aren't. And it makes sense that there's a focus on looking at hazard pay in that context. And yeah, I think that that's going to be continue to be an issue. Obviously, the pandemic hopefully will be a thing of the past at some point, but as long as it's around and people are thinking about it, I think it's going to continue to be an issue, and it should be.
Okay. Well, I'm getting a note that we should probably start to wrap up. So let's go through one more time, starting, if you don't mind, Kyle, with you. Is there anything that we should know about that we haven't discussed that is on the horizon?
Well, obviously there have been some changes at the board recently. I can't forecast, you know, any particular decision I think that the newly Democratic controlled board might issue. But certainly something worth looking at is Jennifer Abruzzo's mandatory submission list to advice, which is GC memo 2104, sort of outlines her priorities, you know, in the next 4 years. I think something that might be relevant to this conversation, and again, I have no idea, you know, what way she's going to want to go on this issue, but you know, we're talking about potential waiver under contract coverage versus a clear and unmistakable waiver in a collective bargaining agreement, and the degree to which, you know, a waiver might allow an employer to act unilaterally with regard to certain issues. She has certainly listed MV Transportation as a case she's interested in looking at and considering. So that is probably something people should keep an eye on, I would think.
Thank you. Jose, is there anything we should be looking at from the State Board of Labor Relations in Connecticut?
Okay, you hear me now?
Yes.
Okay, because you can't see me. The main thing right now is that we recently have received 3 particular cases on the question of whether or not mandated vaccinations are mandatory subject to bargaining. And the corollary in regards to impact bargaining on those matters. We have some other ones that relate to that have issues in regards to mandatory, people being vaccinated fully versus people not being vaccinated fully, and what are the consequences of that. Where in one town, for instance, those who are fully vaccinated are put on and need to quarantine for whatever reasons, are put on administrative time leave, which means they don't touch their accrual. Those who are not vaccinated immediately automatically have to use sick time. And just that type of a issue in terms of mandatory, vaccinated versus unvaccinated, that we have 4 other complaints, that are at preliminary investigation stages.
Well, I think we'll all look forward to both the federal and the state decisions and changes, if there are any, coming forward. Dan, anything we should be looking for?
I guess I would say 2 things. One is that on the question of how these vaccine exemptions play out, there's an issue that really hasn't come up much, because right now the exemptions, if you are exempt, then you can test, and that's the accommodation that the employer makes, right? You can keep working as long as you're tested. there may be situations where that testing exemption is not allowed. And then it's a question of how do you accommodate? And I think there are going to be a lot of interesting questions about how do you accommodate someone who has a religious exemption to the vaccine if testing isn't deemed the approach. So that's one set of things. But the other thing I think is that's out there is that this notion that we can interfere with individual medical decisions to the extent we're doing now, which I support in the sense we're in a pandemic, it's an emergency situation. I can see this being taken too far in lots of different ways. And I think I hope we'll see some pushback against that to the point that, we recognize that interfering with individual medical decisions at the cost of someone's job, it should always be a last resort. It may be right in this context, but it should always be a last resort. And you think about other contexts in which we are very careful to fight for individual autonomy over their own bodies. And that's right. And so I think we just have to be careful that we don't go too far in the balance of protecting individual liberty and choice about their own, what they do with their own bodies at the cost of their jobs. So that's my other thought.
All right, thank you. And we'll end with Gail because she's the boss. So we'll let you make a comment and then you can transition right to being the president of LERA.
Well, I think my dog might be objecting to that. I think one thing we really haven't talked about here, which is maybe a collective bargaining issue, but also a wage and hour issue, revolves the time spent for testing. It involves, sorry, I don't know why he's barking. But I'll just cut it off at that there are times that if we're sending people out to be tested, is the employer required to pay for that person's time? Are they required to pay for the testing? I think those are some of the things that we're going to hear coming forward as well.
Okay. And I'll turn it over to Gail and her dog to close this out.
He always barks when I need to speak. I think it's his way of getting attention. But I do want to thank our panelists, Kyle and Danny and Lee and Jose. I appreciate Mike jumping in as well. I learned a lot during this presentation. I hope everyone did as well. I love the discussion. I wish we had more time because there are things I'd like to pick Dan's brain about too. But we'll all navigate this together. And overall, I think the biggest takeaway here is that we all do what we can to keep each other safe and our community safe. And I hope if we do that, then come the spring, we may be able to have an outdoor luncheon meeting and we could all be together again. And I think that would just be a wonderful thing to happen. So like I said, there will be a recording, a link to this presentation shared with you. We will send out CLE certificates for those of you who need them. And I just thank everyone for participating today and for spending your lunch hour with us. So enjoy the weekend, everyone, and thanks again. That's all I have.
Thank you.
Thank
Thanks,
you.
everybody.
everyone.
Thanks,
Take care.
everybody.
Bye-bye.
Bye.